Welcome back to the program. I have Wisconsin Institute for Law and Liberty. I have Rick Essenberg, the big dog at Will. And it's, with some, discomfort, I bring you on the program, Rick, because we have to talk about something that a lot of people thought we won just a few months ago, and that is the case against the congressional district maps. Remember when we thought we won that one a few months ago, and people like you said, au contraire, they're going to bring back this challenge in a different way. So let's talk about the latest challenge to the congressional district maps, which mean to eliminate at least 2 Republicans from the U.S. House of Representatives.
Right. So, this was decided. This is actually, I think, the 4th go around because, this was decided back in 2022. And what the court did back in 2022 is adopt the congressional maps that were proposed by Governor Evers. And there was an attempt to bring up the congressional maps again right after the balance of power of the court shifted. That was rejected. There was an attempt to get the court to take it as an original action. That was rejected. And now it's happening again. And the question before the court is whether it should appoint a 3-judge panel to hear yet another challenge to redistricting. But this time it's people that are aligned with Democrats challenging the maps that Governor Evers proposed back in 2022 that were adopted by the court, in which the court has declined to interfere with twice. And it's just a game. It's like playing a game of whack-a-mole with an endless supply of moles. And the argument now is, the congressional districts are wrong. I mean, there's one argument that's been made through all of this that the congressional districts are wrong because there's a deviation of 2 voters instead of 1 voter in the in a couple of the congressional districts. Now the argument that we're facing is that we're not trying to make a partisan gerrymandering claim. We think that this was gerrymandered for anti-competitiveness, which, as we point out in our amicus brief, is a theory which has been adopted precisely nowhere by any court. And
that is partisanship, though. And if you're saying it's anti-competitive, you're saying we want a partisan gerrymander.
Well,
that's what you're saying.
What they want, yeah, yeah, you're right. I mean, distinction is very, very hard to discern. You kind of have to squint your eyes and tilt your head at a 46-degree angle, and even then you really can't see it. They don't want to say that this is a partisan gerrymander because the court has pretty consistently refused to take that up, and the Supreme Court has said it's non-justiciable, which is just a fancy way of saying the courts are not going to get into that because they don't have a way to tell whether something is, too partisan or not. So here the problem is that the races are not competitive enough, that somehow when you redistrict, you have an obligation to gerrymander, actually, to rig the lines so that you maximize competitiveness within districts. And our Constitution doesn't require that. There's lots of reasons to think that shouldn't be done because it may be that where people live just doesn't yield competitive districts. And so, this is just another way of making the same old arguments that have been made before, that have been rejected before, in the hopes that, if you just keep, throwing things at the wall, that, sooner or later something will stick.
100% true. So, and I'm thinking rural Wisconsin. So rural Wisconsin, people who are in rural Wisconsin, people who might seek out rural Wisconsin might be a whole lot different than the people who might seek out urban Wisconsin, right? Totally different. We see this all the time. Very blue cities, very red rural areas. But those rural districts, if you've got a congressman representing a rural district, Derek Van Orden, my goodness, we're going to have to get some competitiveness in his district, even though he well represents his district. He is a farmer. He understands the issues. But no. Marc, Elias, and Law Forward say we need competition. That isn't what they want. They want to draw let's talk about excess capacity. They want to draw excess capacity from districts that have cities like Madison in them or cities like Milwaukee in them in order to alter the outcomes of congressional races. And it's that simple. That's their definition of competition.
Well, to some extent, the idea that there's no competition is just preposterous. There's competition. Democrats could compete in say Tom Tiffany's district if they wanted to, but they'd have to run a different kind of candidate. They would have to run the kind of candidate who can make an appeal to the interests and beliefs of the people that live in Tom Tiffany's district. But they don't want to do that. They want to have the district artificially drawn so that they can run pretty much the same kind of candidate they run in Madison and hope to have an opportunity for a victory in a rural district. And quite frankly, they complain a lot of times about tailoring, politicians tailoring the districts to satisfy themselves, and that is exactly an example of that. They want to draw districts that save them from the obligation to appeal to voters where they live and as they are.
They used to have Democrats that were competitive in districts that now they claim are too Republican, and Democrats that won in districts that now they claim are too Republican. And that isn't because those districts are too Republican. That's because the Republicans had changed to address the needs of those districts, and the Democrats stopped addressing the needs. And they decided they wanted the same left-wing, Antifa-style, cookie-cutter, far-left candidate running in every single race. That's what these maps are about. Let's draw it so that those kinds of sort of 20% Democrats can always be the candidates in these elections. So how is it? So this is now trying to make the same claim of partisanship, only using the word anti-competitive. But how does, is it enough, do you think, to get the Wisconsin Supreme Court to bite? They're asking for briefs on this, for Pete's sake. I mean, wouldn't you think you could look at this and go, no, you've already tried this once or twice or four times?
So, I think that this would be a step too far. And I don't know that they're going to take it because I think that, they were, frankly, they were batted down by SCOTUS, by the Supreme Court of the United States in the first redistricting case back in 2022 on the legislative maps where they adopted Governor Evers' maps, and we had to take them up to the United States Supreme Court and get that reversed. They were reversed 9-0 in the Catholic Charities case last term. And while this is a state law issue, the United States Supreme Court has made clear that state legislatures have the power to draw maps. Courts can get involved. Obviously, here the legislature and the governor couldn't agree, but the state courts have to respect the power of the legislature. They have to stay within the confines of normal judicial review. And I just don't know whether doing something like this, where you have sort of multiple challenge to maps in series. You have maps that aren't really particularly, even on sort of standard measures of gerrymandering, they're not particularly gerrymandered. They are, again, Governor Evers' maps. They claim that because the court did a least changes approach back in 2022, that this sort of adopted or was influenced by what they think is a gerrymander in 2011, which was challenged as a gerrymander and was found non-justiciable. And so I think that the court would really be going out on a limb.
Yeah, they want to drag it back 14 years. Yeah, I mean, they want to drag the issues back so long, right? So
to go forward in this case, and I just think that this may be even, for the current majority, this may be a step too far.
I hope so, but I also thought a lot of other things were going to be a step too far, and it turned out they weren't. I noticed Law Forward is not challenging the maps in Illinois for competitiveness, are they? The least competitive maps that I can even conceive of are in Illinois. So this is all to try to get this change done in advance of the 2026 election. They are trying to beat the clock here, correct?
They're trying to beat the clock. I actually think if they were to do this right, it's too late to beat the clock because of the various nomination deadlines. Because if you were actually going to litigate some kind of a gerrymandering challenge, either partisan gerrymandering or if you think there's such a thing as anti-competitive gerrymandering, that is big litigation. I mean, that is big litigation with very complicated expert witnesses reports where, you know, if you're going to, you know, do fairness to the litigation, there has to be substantial discovery and opposition to depositions, and there has to be a trial. And I think it would be very, very difficult to get this
and
done.
They'd lose.
But
they'd probably lose.
Yeah,
it's too complicated.
Yeah, and it has to be done really by sometime in March.
Yeah, so they want the Supreme Court to help them cut in line. That's what they want to do. And the litigation you were describing is so complicated that it could take potentially years. So, but this is the latest. Will has filed an amicus on this, so thank you for doing that. And we'll just keep our eyes on the ball here. Thank you, Rika Essenberg, for being on the program today.
Thank you, Vicki. Take care.